Good evening, everyone, and welcome to today's YCM live session. We are delighted to have with us Ms. Reema Bhandari, ma'am, an advocate with over 26 years of experience. Her work spans across litigation, mediation, and legal writing, with a strong focus on dispute resolution and facilitating fair and effective outcomes for clients. Thank you, ma'am, for being with us here today out of your busy schedule. And ma'am has also been an expert trainer with YCM in several of our past mediation training programs. And we are pleased to have us joining once again with us, again, as I told, despite her busy schedule. So we'll be starting with the first question, ma'am. So you have spent over 2 decades as an advocate. You have worked across litigation and mediation. Looking back, what led you to increasingly value mediation as a tool for dispute resolution?
Yeah, so first of all, I would like to say thank you to Harshita for the wonderful introduction. I have spent more than now 33 years in the practice, not 26. But to start with, yes, the question you asked me, uh, definitely, I am doing mediation from 2007. In India at that time it started. So definitely, I have a lot of passion. That is why I'm being an integral part of the mediation system of our country. So I value mediation. First of all, the important thing which I feel is that the self-determination fact of the mediation process. So it puts, I would say, the person who are actually in dispute, you know, they are having the power to resolve themselves. So it puts the power back into the hand of the people who are actually involved in the dispute. Definitely, it enhances their integrity. It gives them more respect. It gives them more satisfaction when they are getting into the resolution process. Because I totally believe in this one thing that who can understand your problem more than you? So why a third person should be given the opportunity? Why not you yourself? Because you are the best person who knows what is actually the problem and how it can be overcome and how it can be resolved. And and because they are resolving themselves, I feel that because of that only the compliance rate will definitely be more higher because it's their desire which is getting fulfilled. They are tailoring the whole solution. The second important aspect here is voluntariness. Because it's a voluntary process, it can lead to a lot of creative solution. There can be a lot of brainstorming because people are sitting voluntarily with the mindset to resolve. So it leads to a unique settlement arrived between the parties, tailored according to their specific needs. And the most important pillar of mediation is confidentiality. The confidentiality leads to disclosures. Confidentiality leads to fearless participation in the mediation process by the parties. So without this, they are not scared. They are not under any kind of fear of public exposure or any legal repercussions if the case goes back to the court. So because of that, they are able to share a lot of sensitive information, their underlying interest, which actually help the mediator to assist them properly in the mediation process. And I would say confidentiality is the most important factor which differentiates mediation from other forms of ADR. A further mediator, I would say, it facilitates the open dialogues and communication between the parties, which was not happening for a longer time. So it opens a channel of communication, and people are able to express their feelings. They are able to express their interest, and because when there's a direct communication between the parties, there can the lot of misunderstandings, they can be taken care of. They are cleared. They are able to respect. They can understand each other perspectives, and because of that, it the process moves towards resolution. So I would say mediator not only builds the relationships, the communication channel, but the other factors apart from all these factors are that mediation saves time, money, and lot of tensions which people go through if they continue in the litigation process.
Thank you, ma'am, for summing it up very beautifully. And I think at present, considering the backlog of cases. What you said totally makes sense. Even from a student's perspective, it was much easier for me to understand your point. So,
Thanks.
moving forward to the next question, that is, from your experience, how does a litigator's mindset differ when they step into mediation, and what's often the hardest shifts for lawyers to make in that situation?
Okay. So, definitely, a conscious shift in the mindset is required when a litigator or a counsel they enter into the mediation process. The the mindset should be there from winning a case to resolve the case, from an adversarial mindset towards a cooperative mindset, to have an approach where people can sit together and resolve. They should be focusing more on the future than what has happened earlier in the past. And parties are able to make realistic assessments about their cases with the help of their lawyers first, and then with the help of the mediator. Uh, Coming to the mindset of lawyers, definitely I would say the role of lawyers is indispensable in the mediation process. A mediator and a parties, definitely they both need the lawyers very well in the process, because the parties they need advice when they are deciding what to do. They are not aware about the legal, uh, you know, arena. They are not aware about a lot of things. So they will definitely need their lawyer to consult. More so when a mediator cannot give suggestions. So who will give them suggestions? Definitely their lawyers, whom they trust more than a mediator, whom they have paid for that also. They know the case better than mediator also. So they are definitely there to assist them in the evaluation process, to give them legal guidance if it is required. And they are part of they prepare the clients before they come to the mediation. They, help them in expressing themselves. They help them while the matter is getting drafted. So their role, I would say, it starts from even the mediation begins and till the mediation ends. But the mindset where mindset has to be changed little bit from, because we are lawyers, we should not be blamed like that. I am a lawyer too. So but the mindset has to change. So I would like to say that the mindset has to change from adversary to advisory, from the desire. We have to let go the desire to win. We have to understand that I'm actively listening somebody, not to reply. It's not an argument. I have to actively listen to understand the perspective of the other side. So a complete mindset, the role of a lawyer in the mediation. Definitely there are a lot of programs on mediation advocacy are happening, in which, so the lawyers are acting. Their cap is different when they are in the court, but their cap is different when they are in the mediation process.
Yes, ma'am. Thank you for that. And the next question is, in real mediations, what usually makes the difference between a discussion that goes in circles and that moves towards resolution?
Okay. So to answer this, I would say, divide it in two parts. One is, let's understand why discussion moves in circles first. Why, and initially in all the mediation, it starts like that only. So why it moves in circles? Because, the parties are stuck in their positions, what they demand, their legal position, and they keep on repeating. You can hear them saying, oh, his claim is, it's not the, why should I pay, I'm not liable to pay, that legal language, or the claim is exaggerated by the parties. They have that blame game with each other. So they are stuck because of those legal positions. And the other reason I feel they are stuck is when their emotions are not addressed. you know their trust is broken. They feel disrespected by the other side, and there's a fear of, if they settle, they can lose something, something can be taken away from them. So what I would, when their needs and interest, they remain hidden in the subtext underneath the talks, they will move in circles. So as a mediator, first you have to understand this, that why they are moving in circles like this. Now, after a mediator understand this, now the role of mediator starts from moving them from this towards a resolution. Now, how a mediator does, that is the main training about mediation is that a mediator brings a clear shift from what is right to what happens net. You know, you should not be stuck what is right and wrong, but you should move now. What happens now? This is the position. This is what has happened. Now the damage is done, but now what to do? How to move in future? So the mediator tries to make the parties see the future perspective of the dispute. And for that, mediator use lot of skills. He neutrally reframes. Mediator asks different kind of questions, open questions to gather information, ask question to understand their interest, ask question, a hypothetical question to what they are looking for in future. Then mediator, builds an empathetic bond with the parties so that there is a repo between a mediator, so that if there is that confidence between a mediator and the parties, only that mediator can shift it from the talks from in circle which are moving to a collaborative settlement or towards a resolution. So a lot of things mediator does. It does a lot of separate session in which he is trying to get more information. So in which he does a lot of reality checks, like from what would a court decide to what is the risk if you go back to the court. These kind of questions mediator ask. So in the end, yes, I would like to say this thing, that momentum in mediation begins the moment parties stop talking about the past and they start talking about the future. So
I don't think it could have been explained any much better. It's like the way you divided the sections. It makes it much easier to understand. Thank you for that, mom. I hope our viewers are listening to this and making something out of this.
hope
Moving to
so, hope so.
Moving to the next question, that is, what is one mistake you frequently see young lawyers or parties make in mediation, and how could they approach this process more constructively to avoid such mistakes?
Okay, so I won't call it a mistake, Harshita. Uh, I would say that they're not aware about their role in the mediation process. They're not aware. There is lack of awareness, which we all are trying to create this awareness by conducting these kind of sessions. So they are not aware. They start treating mediation, I would say, as a trial. They start using aggressive language. They open up with demand which is definitely very high, which breaks the momentum and escalates the conflict further. And they also at times they do not do the case analysis, the strength and weaknesses about the cases which they are handling. They're not preparing their parties to negotiate, how to negotiate in the mediation process. And parties are also at times, they are also over expectations are there in the mediation process. They are coming with lot of expectations. They are not aware about the reality check which a mediator does in the mediation process. And most of the time they're controlled by their emotions also. They can't see beyond what has happened to them. So because of this reason, they actively do not participate at times also. So all these problems are there, and it can be improved if the parties, they are prepared thoroughly before the mediation by their lawyers, where they understand their rules, what they can do, what they cannot do, how they manage their expectations, they adopt a problem solving approach. So, and they should know how to use a mediator effectively, actually. So, this is what they should not start with an extreme opening offers. They should have a strategic anchor price so that parties can move towards resolution.
Thank you, ma'am. So, moving to the next question, that is, now that the Mediation Act has been introduced and it's been passed and everything, what is the future of mediation from your perspective?
Well, Mediation Act, definitely. Mediation Act in India was introduced in 2023, and few provisions are notified, and we all know few have to be notified, and we are all waiting for that desperately here. But definitely, it is going to make mediation more structured. more accessible, and will definitely include a technological ecosystem. Now, so like mediation settlement agreement, I will call it MCAs, they will definitely have now the same legal status as a court decree. So the enforceability of this settlement will not be an issue. Then there will be institutionalization of mediation through MCI, that is Mediation Council of India, which is in the process. It will come, we all are expecting it to come soon. So, MCI is definitely going to be a central regulator which will be responsible for accrediting mediators, for registering mediators, for accrediting institutions which can conduct mediations, and it will set high ethical standards also to conduct mediation. Definitely, the act formalizes community mediation so that mediation root reaches at the grassroots level to have more peace and harmony in the society. It also significantly professionalizes commercial mediation to boost the investors and ease of doing business in the country. And actually, I would say the act also formally recognizes online mediation also through virtual platform so that geography should not be a barrier. So a lot of things are going to come up. We are all just waiting for the act to be notified and MCI to come in force as soon as it's possible.
Yes, ma'am. It's very exciting to see how the future of the mediation
Yes,
will
yes.
go
It's in your
forward.
hands, the young generation.
Yes, ma'am.
Yeah.
Moving on to the next question. You've been an expert trainer with YCM in several of our past trainings. From
Hmm.
working closely with participants, what gaps do you most often notice between theoretical understanding and practical mediation skills?
Well, definitely there is a core gap between the two, between the theory and the practice. That is why we include a lot of, role plays are there in our training programs, are definitely there, whether it is an online training or it's a physical training or hybrid training program also. We are keeping days for these role plays. So they are very, very important. And I will give you an example. Like in theory, what we do is in theory, we say a mediator has to be neutral and impartial. We all know. And definitely, it is one of the strong pillar of mediation. Mediator has to be neutral and impartial. But in practice, what happens? It is very difficult to remain neutral all the times. We are human beings, our own biases, my own culture, my experience, my thought process. It can come in between the process of mediation. So, because mediators are not passive, they are actually passive observers. Their presence fundamentally change the dynamics of the room. So, we in these trainings, through these role plays, we train them that how to handle this situation, how to keep your mindset, your culture, your biases, your assumption outside the mediation room. Understand the parties the way they want you to understand them. So this is the difference, there are other also like imbalances is another issue. Like we say that the parties have to self-determine, but if what a mediator, what is the role of a mediator when he sees that there's a power imbalance happening? One party has more knowledge, the other one is very weak. They don't understand. So how a mediator handles such situations? So these role plays, they give them all those practical help to handle such situations.
Thank you, ma'am. Now that you have mentioned role play, this question can be taken as a follow-up.
Hmm.
Why do you think structured mediation training with role plays, feedback, and mentoring is especially important for students and early career professionals?
Well, role plays and these feedbacks, immediate feedbacks, which we provide immediately, the role plays over coaching, mentoring, they are actually the golden standards of the training program. This multifaceted approach definitely, is essential in any training because mediation is a very human centric process, and where the skills like communication skills, how to build empathy, and active listening, all those skills they have to be learned. So these things they cannot be just learned by reading in a textbook or by listening somebody or by just watching a ppt presented by a trainer. So it is very important to learn these skills by doing. So when a feedback is provided, and we provide a feedback in a very positive manner, we always try to give, when we give the feedback, we are very cautious about the language we are using. First, we try to motivate the trainee that the positive things they have picked up, and then we tell them that there's a chance of improvement or all. So they are motivated, they do not lose their confidence. But the way it is told, so that they immediately learn by doing. So what we do is we finish one particular topic. For example, I've explained them what is communication, the skills of communication, and immediately a role play will be done in which we will be looking forward so that we can see that whether they are able to display those skills of active listening, summarizing, all those skills. So they are definitely non-negotiable. They have to be there in the training programs.
Yeah, mom. Thank you for that, mom. And I really like the way you explained how a feedback should be given, because that is a factor that decides if it encourages them to further do it, or to like, okay, I am
Yeah,
done
yeah,
with this, I'll back down. So I am very glad to hear about that. And mom, earlier you mentioned about how um person's basic beliefs and neutrality can also be embodied in a mediation by a mediator. So
yeah.
now, what is the role of ethical code for a mediator? Is the question.
Ethics. That's my favorite topic also in all the trainings. I jump to, to speak on this. So ethics are basically what ought to be done. You know? So it can be different for different people, but for mediators, there can be only one set of ethics. You cannot change this. So they are, I would say, the invisible foundation of the mediation process. Now the act will come, but before that, they were mentioned in the guidelines issued by the MCPC, the Mediation Conciliation Project Committee of Supreme Court of India, which lays down them. And definitely, the mediation cannot proceed if a mediator is not able to handle the ethical code of mediation. So, because it is necessary, they are very necessary because they ensure the integrity of the process, they ensure the legal finality of the process. Like, it is a duty of the mediator, first of all, to maintain the confidentiality. If a mediator is not able to do, though, definitely mediator will be changed and people will not trust the mediation process. And mediator tells about this in the beginning itself when the mediator gives the opening statement that it is I'm duty bound ethically. There are rules, there are judgments, there are ethical codes. So I'm duty bound. So they are. I will not be telling to the court if the mediation is not set, a case is not getting settled. And definitely in the separate session, this confidentiality is reassured. Then, secondly, it is duty of the mediator to keep the process voluntary. It is the duty of the mediator to maintain the parties' autonomy. They should not be under any force or coerced to come to a settlement. So, this way, I would say that their duty is only to facilitate the mediation process, not to act as a judge, not to act as a counsel, not to give any suggestions. So, this everything lies on the shoulders of a mediator. So, they have to be very careful. So in that, I would say definitely ethics are the soul of core of mediation process, which transforms a negotiation process towards a settlement. And the mediator is a guardian of this party's dignity and autonomy.
Thank you, mom. I remember in the previous cohort, the October-November batch, you took mediatorization. Yeah, I was there in that batch, and I was very keenly listening to everything. It was like you put a lot of emphasis on confidentiality and autonomy of party even then. So I remember it much clear, and I really did
But I
enjoy
totally
listening.
believe in that, Harshita, because without this ethics, then people will not trust mediation. So they're actually the backbone of the mediation process.
Yes. Yeah, ma'am. So thank you for that, ma'am. It was a wonderful session even then, and even now it's very really wonderful listening to you.
Thank
And
you.
moving
We
moving
should
on to the
we should
next.
meet surely one day whenever you are in Delhi.
Sure, ma'am. Sure. Next question is: by the end of the course, what do you hope participants develop not just as mediators but also as legal professionals?
Okay. So I would say the aim of the training program which we are conducting with YCM or wherever I'm a part of a training program, I always feel that we are not concentrating more on the you know uh, that there should be more professionals, or we are not creating mediators only. The aim is much higher. Okay, so the aim is to enhance personal growth, professional growth. The aim is to enhance lot of skills like communication skills. If a person is taking training, they learn how to actively listen. They know how, they understand what is empathy, how to display empathy. So this help them in their personal life also, to or in the professional life also. This communication skills, they help a lot. And they understand what kind of questions to be asked, what time they should be asked, the pitch of voice. This all is a part of our communication curriculum. Then they are also able to understand the emotional triggers. They are able to understand what is not even said, what is there behind those emotions. Then they are able to learn the problem solving skills. They are also able to learn how to remain calm when people are emotionally disturbed. They learn to be more patient. Perseverance, be optimistic. Definitely we'll try more, we will have more out of box thinking. So all these things, which they are going to imbibe during this process, is definitely going to help them more in their professional and personal life, apart from being in their being there as a
Just as a mediator.
mediator. Yeah.
Yeah. I don't know about the further participants, but ma'am, I can assure you that I think I've at least learned and carried forward 80% of this after your training or much other trainers training. So it is not only helpful in the professional aspect, but even in your personal life.
Yeah.
It helps you in much better way for you to lead a much better life.
And it
So
has changed us also, Arshita, as a mediator. I have changed myself. I can see those changes in myself also. Let's be very honest. Yes, we all have learned a lot.
yes, mom, we did. And I
Yes,
think it's
yes.
very, very optimistic and helpful for you to be a better person at the end of the day. And moving to our final question for this
Good.
session. After everything that you have seen in practice, what is one principle about mediation or dispute resolution that you believe lawyers tend to underestimate?
Uh, the lawyers underestimate about the mediation process.
Yes.
Okay. So the lawyers, definitely, I would say they underestimate is the importance of uh, considering the underlying need and interest of the parties at times. They are not able to at times understand the personal dynamics between the parties. Why? It is not that they are wrong in doing so, because they are lawyers. We are bound to think, in a legal way. So, because of that, they are into the mindset of winning in the court. They are into the mindset of their legal rights. Even if the parties is willing to give something of the claim, they feel, no, no, you can get this much from the court. Why are you giving up? But they're not able to at times understand that maybe the relationship is more important for that party. Maybe the apology is more important for the party. So there are a lot of non-monetary things which are more relevant for the parties. So because they are stuck up in that their legal rights and and all those things, so these are few important things uh, they should consider more when they are there in the mediation process. Otherwise,
Yeah.
definitely, lawyer's role is always very, very important.
This reminds me of when once, I think the first time in one of the training, I heard Kudrat Dev say that, mediation is not only about solving the problem, but then it's also about preserving the relationship between the parties.
Yes.
That is why mediation plays a much bigger role than litigation,
And which
because
is not there in arbitration,
yes,
litigation, and your what I say, lok adalat and other kind of ADRs. It's not
that
there.
makes mediation much
Much,
unique.
yeah, yeah. It's the
Yes.
first place where parties are heard properly. They are getting an opportunity to speak for themselves. They are not being judged
And
right
they
or
also get
wrong.
the space to vent out, which
Went
also
out.
releases a lot
Yeah,
of pent up emotions. And I don't think any other space in legal matters or in legal
exactly. Yeah, yeah.
resolution you get that space. Thank you, ma'am. It has been very wonderful listening to you, and thank you for sharing all your insights with us today. Your
Welcome,
perspective on
Harshita.
mediation,
Thank
which
you.
is like it's not only rooted from mediation, but it is also rooted from litigation, which gives me a whole different view on mediation for me personally, because I've only spoken to like people who have done mediation as a basis and then developed henceforth, but then listening from a litigator who then stepped into mediation is a complete different perspective for me personally.
Thank you. Thank you. I do now feel that everything should be first settled, go for the settlements, and then go to the court. If
Yes.
if it fits into the case, the kind of cases which can be sent to mediation, then it must be.
Yes, ma'am.
No,
And I
but
hope.
all the best to the students like you, who you are taking, good initiatives and a part of a team. And definitely, you are going to take the movement further. We are to now going to give the baton in your hands now. So all the best, and definitely let me know whenever you are in Delhi. We'll definitely
Sure, I'm sure.
help
Thank
you.
you for that, Mom. It's a great pleasure for me to be able to even interview you and to be able to share this 30 minutes of space with you. And for those who have listened to us today, I hope you are also having some takeaway from this. And if you're interested in becoming a mediator, we have our JanFeb course live now. You can contact YCM team anytime, and we'd guide you further. Thank you, ma'am, once again for taking your time out on a Sunday to be here with
Yeah.
us.